Tushar Mehta, as was pointed out by Brother Vishwanath, if you look at it carefully, just read subsection 1,
Yes.
Article 34, or clause 1 of Article 34.
Recourse to a court against an arbitral award may.
Now pause. In the territory of this state, under this law. So basically, they were, in this stage, Unicitral was trying to adopt a universal law for commercial arbitration. So that's why the bracketed portion says in the territory of this state. So they wanted to specify in the territory of the state where you will be able to file the petition and which is the law which will be applicable. It is quite, therefore, what it was trying to do was we may have adopted the unicitral model into our domestic arbitration, but with changes. Because obviously, when we are dealing with domestic law, we are not going to mention the law which will be applicable. Neither are going
We
to
say under this act.
or under this act.
I'll answer it, my lord, in two ways. Your lordships are right. What happens is, this was a model law.
Now, there was an issue over there. What was happening is, and it continues to remain, under the New York Convention, it continues to remain the same. You make an award, the seat of arbitration or the law of arbitration which is applicable, say, is country A. Now, you will, under that law, you'll file challenge to that award. A party which is dissatisfied may file a challenge to that award and may lose. Now, the law of res judicata is the original cause of action gets subsumed into the decision of the court. So you cannot sue on the basis of the original cause of action.
In regular courts.
In regular, what happens is the original cause of action no longer survives because what is there is now the adjudication. So what you can enforce today is the order or the decision and not, you can't take recourse to the original cause of action in any other country. So that's done by the recognition part of international awards. But because the international award, once it's recognized, you can't take recourse to the original cause of action. You can't file a civil suit, get an ex parte judgment, or anything like that. Or even you can't initiate proceedings. But as far as India, what we are concerned today is far more crucial. It doesn't appear that this convention, if it had been implemented, then the second stage of objections under 48 would have become redundant.
May I answer that question? Lord, please read one again. A recourse to a
No,
court.
but now what is happening is, suppose, say, award is made in country A. The party which loses may take recourse to appellate remedy, may not take recourse to appellate remedy. But when the enforcement of the award or execution of the award takes place in country B, because the assets of the losing party or the judgment debtor are in country B, you can take recourse to 48, which is almost pari materia with earlier part of 34.
For the time being, my lord,
Unamended 34.
for the time being, my lord, I'm not responding to some part of it. My lord, may I answer? How, my lord, I read it, and according to me, my lord, this appears to be the intention after having gone through the entire working group report is, please read one. What is intended? A recourse to a court against an arbitral award made in the territory of India under Indian Arbitration Act may be made only by an application for setting aside in accordance with paragraph 2 and 3 of this article. Kindly pause here for me. Lord, it was open for every country to provide for either domestic arbitration and foreign seated arbitration, or as we say, international commercial arbitration. Lord, for example, in India, part 1 deals with domestic arbitration. Part 2 deals with international commercial arbitration. We have a combined comprehensive legislation, and it says recourse to a court against an arbitration award made in India under the Act may be made only under Section 34. In, for example, Singapore, they have two separate arbitration law. One for domestic arbitrations, another for international arbitrations. We have chosen a model which provides both for domestic as well as international arbitration in one legislative framework. And therefore, my lord, this was intended, I can, my lord, assure your lordships, my lord, this was intended to become a model both for domestic as well as foreign arbitrations. it was open for the respective countries to make suitable modifications depending upon their domestic requirements. And such suitable changes are made by some countries. But we have accepted this both for domestic as well as for foreign international commercial arbitration. And the commentary also, my lord, and the way in which it was, my lord, kindly come to page 931. This may, my lord, answer your lordship's, my lord, concern. My lord, objection reasons also mentions, Ansita.
Yeah, that it is specifically
it-
stated.
It does.
Mr. Rao was the secretary at that time, had worked on it as a unicitral model of, it was specifically stated at that time. When ordinance came, there were some issues, then I think repeatedly ordinance came, because it matter remained under consideration, there was debate and issues, and then 1996 Act came.
My lord, he wrote a book. I have included extracts from that. He's written a book of the 96 Act. I'll show in my turn.
Anyway, my book is ultimately a personal. I'm reading
we were part of that growing up years at that time. Far knowing.
Sole action for attacking award, paragraph 1. But please come to page 931. Existing national laws provide a variety of actions or remedies available to a party for attacking the award. National laws, not domestic laws, they are talking. Often equating arbitral awards with local court decisions, they set very varied and sometimes extremely long periods of time and set forth varied and sometimes long list of ground on which the award may be attacked. Article 34 is designed to ameliorate this situation by providing only one means of recourse, para 1, availing during a fairly short period of time, para 3, and for a rather limited number of paragraphs. So it is a
You're right. To that extent, probably the intent was that you amend the domestic laws
also in tune with this.
so that the challenge is also on limited number of grounds and same grounds which are available when you challenge the New York Convention Award.
Exactly. I'm grateful.
But
then next,
have we restricted ourselves to that?
we have. I can't say whether fortunately or unfortunately, but in 96, we were not under any obligation not to deviate.
After 96.
Lord, it's evolving. I can say, my lord, it's evolving, but ultimately, my lord, some way will have to be found. But at the end of my submissions, my lord, the way can be somewhere else, not
So
here.
the idea was the national and international should be the same grounds. So it becomes the enforcement of the awards becomes
easier. And, my lord, also incentivizing other jurisdiction parties to come here and arbitrate on the ground that arbitrate award would be final. There would be very limited challenge to it. So your dispute resolution would be faster. Suppose we have 15 grounds or we have 20 grounds, then it might disincentivize others to come. That may be, my lord, perhaps the intention. Please come, my lord, now to para 2. The application for setting aside constitutes the exclusive recourse to a court against the award in the sense that it is the only means for actively attacking the award, that is, initiating proceedings for judicial review. A party retains, of course, the right to defend himself against the award by requesting refusal of recognition of enforcement in proceedings initiated by the other party. Obviously, Article 34(1) does not exclude the right of a party to request any correction or interpretation of the award or making of an additional award under Article 33, our limited, but our Section 33, clerical and mathematical errors. Since such request would be directed to the arbitral tribunal and not to a court.
Give me the arbitration. Continue.
No, your lordship may see. I would like your lordships to be with me in reading this.
The teaching, in fact, goes beyond that. Beyond that, it goes also.
I'm saying more.
Clause B goes beyond that.
Yes.
It says, if so agreed by the parties, a party which is a notice to the other party may
request the arbitral tribunal to correct any computation errors, any clerical or typographical errors, or any other errors of a similar nature
Then B, if so agreed.
My lord, this is Article 33,
That's
Clause
fine.
B.
That clause B now.
Page 9.
page 929. My lord,
That's B of section 33. Asking the arbitrator
if so
to
agreed by a
interpret
party
the
with notice to the other party may request the tribunal to give an interpretation of a specific point. My lord, 929, this Ancestral Article 33 also has that.
Same is there.
Same, 929, my lords. To give an interpretation of a specific point or part of the award.
Okay.
We have, my lord, done an excellent work of copy pasting, my lord, at that time, my lord. Then, my lord, kindly come to 934. Again, my lord, we are not on remission. My lords are examining modification, but still I may show what they felt. Paragraph 4, which becomes our third section 34.4. Envisage is a procedure which is similar to the remission known in most common law jurisdiction, though in various forms. Although the procedure is not known in all legal systems, it should prove useful is that it enables the arbitral tribunal to cure a certain defect and thereby save the award from being set aside by the court. So defect, that was the intention. Unlike in some common law jurisdictions, the procedure is not conceived as a separate remedy, but placed in the framework of setting aside proceedings. We have done this, my lord. It's a part of 34, our 34. The court, where appropriate and so requested by a party, would invite the arbitral tribunal whose continuing mandate is thereby confirmed to take appropriate measures for eliminating a certain, please mark, remediable defect which constitutes a ground for setting aside under paragraph 2. So first it has to be remediable defect and it should be severable. But my lord, there are judgments where despite the power of remand or remission having been exercised, the tribunal says that no, we uphold our decision. Matter goes back to my lord, the court which we call 34 court. And court said, now we have no other remedy, we set it aside. That's how, my lord, internationally, unless in some countries where they have deviated while making their domestic law to be non-compliant to Article 34.